Constitution of India, Chapter 3, the State Legislature, Article 168 to 212. General. Article 168, Constitution of Legislatures in States. For every state there shall be a legislature which shall consist of the governor, and in the state of Andhra Pradesh, Bihar, Madhya Pradesh, Maharashtra, Karnataka, Tamil Nadu, Telangana, and Uttar Pradesh, 2 houses. In other states, 1 house. Where there are 2 houses of legislatures of a state, one shall be known as the Legislative Council and the other as the Legislative Assembly. And where there is only 1 house, it shall be known as Legislative Assembly. Article 169, Abolition or creation of Legislative Councils in states. Notwithstanding anything in Article 168, Parliament may, by law, provide for the abolition of the Legislative Council of a state having such a council, or for creation of such a council in a state having no such council, if the Legislative Assembly of the state passes a resolution to that effect by a majority of the total membership of the Assembly, and by a majority of not less than 2/3 of the members of the Assembly present and voting. Any law referred to in Clause 1 shall contain such provisions for the amendment of this Constitution as may be necessary to give effect to the provisions of law, and may also contain such supplemental, incidental, and consequential provisions as Parliament may deem necessary. No such law as aforesaid shall be deemed to be an amendment of this Constitution for the purpose of Article 368. Article 170, Composition of the Legislative Assemblies. Subject to the provisions of Article 333, the Legislative Assembly of each state shall consist of not more than 500 and not less than 60 members chosen by direct election from territorial constituencies in the state. For the purposes of Clause 1, each state shall be divided into territorial constituencies in such manner that the ratio between the population of each constituency and the number of seats allotted to it shall, so far as practicable, be the same throughout the state. Explanation. In this clause, the expression population means the population as ascertained at the last preceding census, of which the relevant figures have been published. Provided that the reference in this explanation to the last preceding census of which the relevant figures have been published shall, until the relevant figures for the first census taken after the year 2026 have been published, be construed as a reference to the 2001 census. Upon the completion of each census, the total number of seats in the Legislative Assembly of each state and the division of each state into territorial constituencies shall be readjusted by such authority and in such manner as the Parliament may by law determine. Provided that such readjustment shall not affect representation in the Legislative Assembly until the dissolution of then existing Assembly. Provided further that such a readjustment shall take effect from such date as the President may, by order, specify, and until such a readjustment takes effect, any election to the Legislative Assembly may be held on the basis of the territorial constituencies existing before such readjustment. Provided also that until the relevant figures for the first census taken after the year 2026 have been published, it shall not be necessary to readjust the total number of seats in the Legislative Assembly of each state as readjusted on the basis of 1971 census, and the division of such state into territorial constituencies as may be readjusted on the basis of 2001 census under this clause. Article 171, Composition of the Legislative Councils. The total number of members in the Legislative Council of a state having such a council shall not exceed 1/3 of the total number of members in the Legislative Assembly of that state. Provided that the total number of members in the Legislative Council of a state shall in no case be less than 40. Until the Parliament by law otherwise provides, the composition of the Legislative Council of a state shall be as provided in Clause 3. Of the total number of members of the Legislative Council of a state, as nearly as may be, 1/3 shall be elected by electorates consisting of members of municipalities, district boards, and such other local authorities in the state, as Parliament may by law specify. As nearly as may be, 1/12 shall elected by electorates consisting of persons residing in the state who have been for at least 3 years graduates of any university in the territory of India, or have been for at least 3 years in possession of qualification prescribed by or under any law made by the Parliament as equivalent to that of a graduate of any such university. As nearly as may be, 1/12 shall be elected by electorates consisting of persons who have been for at least 3 years engaged in teaching in such educational institutions within the state, not lower in standard than that of a secondary school, as may be prescribed by or under any law made by Parliament. As nearly as may be, 1/3 shall be elected by the members of the Legislative Assembly of the state from amongst the persons who are not members of the Assembly. The remainder shall be nominated by the Governor in accordance with the provisions of Clause 5. The members to be elected under subclause A, B, and C of Clause 3 shall be chosen in such territorial constituencies as may be prescribed by or under any law made by Parliament, and the elections under the said subclauses and under subclause D of the said clause shall be held in accordance with the system of proportional representation by means of single transferable vote. The members to be nominated by the Governor under subclause E of Clause 3 shall consist of persons having special knowledge or practical experience in respect of such matters as the following, namely literature, science, art, cooperative movement, and social service. Article 172. Duration of state legislatures. Every legislative assembly of every state, unless sooner dissolved, shall continue for 5 years from the date appointed for its first meeting, and no longer, and the expiration of the said period of 5 years shall operate as a dissolution of the assembly, provided that the said period may, while a proclamation of emergency is in operation, be extended by Parliament by law for a period of not exceeding 1 year at a time, and not extending in any case beyond a period of 6 months after the proclamation has ceased to operate. The Legislative Council of a state shall not be subject to dissolution, but as nearly as possible 1/3 of the members thereof shall retire as soon as may be on the expiration of every second year in accordance with the provisions made in that behalf by Parliament by law. Article 173. Qualification for membership of the state legislature. A person shall not be qualified to be chosen to fill a seat in the legislature of a state unless he is a citizen of India and makes and subscribes before some person authorized in that behalf by the Election Commission an oath or affirmation according to the form set out in the purpose in the third schedule. Is in the case of a seat in the Legislative Assembly not less than 25 years of age, and in the case of seat in the Legislative Council not less than 30 years of age, and possesses such other qualifications as may be prescribed in that behalf by or under any law made by Parliament. Article 174. Sessions of the state legislature, propagation and dissolution. The Governor shall from time to time summon the House or each House of the legislature of the state to meet at such time and place as he thinks fit, but 6 months shall not intervene between its last sitting in one session and the date appointed for its first sitting in the next session. The Governor may from time to time prorogue the House or either House, dissolve the Legislative Assembly. Article 175. Right of Governor to address and send messages to the House or Houses. The Governor may address the Legislative Assembly, or in the case of a state having a Legislative Council, either House of the Legislature of the state or both Houses assembled together, and may, for that purpose, require the attendance of members. The Governor may send messages to the House or Houses of Legislature of the state, whether with respect to a bill then pending in the legislature or otherwise, and a House to which any message is to send shall with all convenient dispatch consider any matter required by the message to be taken into consideration. Article 176. Special address by the Governor. At the commencement of the first session after each general election to the Legislative Assembly and at the commencement of the first session of each year, the Governor shall address the Legislative Assembly, or in the case of a state having a Legislative Council, both houses assemble together and inform legislature of the causes of its summons. Provision shall be made by the rules regulating the procedure of the House or either House of allotment of time for discussion in the matters of vote in such address. Article 177. Rights of Ministers and Advocate General as respects of the Houses. Every Minister or Advocate General of a state shall have the right to speak in and otherwise to take part in the proceedings of the Legislative Assembly of the state, or in the case of the state having a Legislative Council, both houses, and to speak in and otherwise to take part in the proceedings of any committee of the legislature of which he may be named a member, but shall not by virtue of this article be entitled to vote. Article 178. The Speaker and Deputy Speaker of the Legislative Assembly. Every Legislative Assembly of a state shall as soon as may be choose 2 members of the Assembly to be respectively Speaker and Deputy Speaker thereof, and so often as the office of the Speaker or Deputy Speaker becomes vacant, the Assembly shall choose another member to be Speaker or Deputy Speaker as the case may be. Article 179. Vacation and resignation of and removal from the offices of Speaker and Deputy Speaker. A member holding office as a Speaker or Deputy Speaker of an Assembly shall vacate his office if he ceases to be a member of the Assembly. May at any time by writing under his hand addressed, if such member is a Speaker, to the Deputy Speaker, and if such member is the Deputy Speaker, to the Speaker, resigns his office, and may be removed from his office by a resolution of the Assembly passed by a majority of all then members of the Assembly, provided that no resolution for the purpose of clause C shall be moved unless at least a 15 days notice has been given for the intention to move the resolution. Provided further that whenever the Assembly is dissolved, the Speaker shall not vacate his office until immediately before the first meeting of the Assembly after the dissolution. Article 180. Power of the Deputy Speaker or other person to perform the duties of office or to act as Speaker. While the office of Speaker is vacant, the duties of the office shall be performed by the Deputy Speaker, or if the office of the Deputy Speaker is also vacant, by such member of the Assembly as the Governor may appoint for the purpose. During the absence of the Speaker from any sitting of the Assembly, the Deputy Speaker, or if he is also absent, such person as may be determined by the rules of procedure of the Assembly, or if no such person is present, such other person as may be determined by the Assembly shall act as Speaker. Article 181. The Speaker or the Deputy Speaker not to preside while a resolution for his removal from office is under consideration. At any sitting of the Legislative Assembly, while any resolution for the removal of the Speaker from his office is under consideration, the Speaker, or while any resolution for the removal of the Deputy Speaker from his office is under consideration, the Deputy Speaker shall not, though he is present, preside, and provisions of clause 2 of Article 180 shall apply in relation to every such a sitting as they apply in relation to a sitting from which the Speaker or as the case may be, the Deputy Speaker is absent. The Speaker shall have the right to speak in and otherwise to take part in the proceedings of the Legislative Assembly, while any resolution for his removal from office is under consideration in the Assembly, and shall notwithstanding anything in Article 189 be entitled to vote only on the first instance on such resolution, or on any other matter during such proceedings, but not in the case of an inquiry of equality of vote. Article 182. The Chairman and Deputy Chairman of the Legislative Council. The Legislative Council of every state having such council shall as soon as may be chosen 2 members of the council to be respectively Chairman and Deputy Chairman thereof, And so often as the office of chairman or deputy chairman becomes vacant, the council shall choose another member to be chairman or deputy chairman as the case may be. Article 183. Vacation and resignation of and removal from the offices of chairman and deputy chairman. A member holding office as chairman or deputy chairman of a legislative council shall vacate his office if he ceases to be a member of the council. May at any time, by writing under his hand, addressed, if such member is the chairman, to the deputy chairman, and if such member is the deputy chairman, to the chairman, resign his office, and may be removed from his office by a resolution of the council, passed by a majority of all the then members of the council, provided that no resolution for the purpose of clause C shall be moved unless at least 15 days notice has been given of the intention to move the resolution. Article 184. Power of the deputy chairman or other person to perform the duties of the office or to act as chairman. While the office of chairman is vacant, the duties of the office shall be performed by the deputy chairman, or the office of the deputy chairman is also vacant, by such member of the council as the governor may appoint for the purpose. During the absence of the chairman from any sitting on the council, the deputy chairman, or if he is also absent, such other person as may be determined by the rules of procedure of the council, or if no such person is present, such other person as may be determined by the council shall act as chairman. Article 185. The chairman or the deputy chairman not to preside by the resolution of his removal from office is under consideration. At any sitting of the legislative council, while any resolution for the removal of the chairman from his office is under consideration, the chairman, or while any resolution for the removal of the deputy chairman from his office is under consideration, the deputy chairman shall not, though he is present, preside, and provisions of clause 2 of Article 184 shall apply in relation to every such a sitting, as they apply in relation to the sitting from which the chairman, or as the case may be, the deputy chairman is absent. The chairman shall have the right to speak in and otherwise to take part in the proceedings of the legislative council while any resolution of his removal from office is under consideration in the council, and shall, notwithstanding anything in Article 189, be entitled to vote only in the first instance on such a resolution or on any other matter during such proceedings, but not in the case of an equality of votes. Article 186. Salaries and allowances of the Speaker and Deputy Speaker and Chairman and Deputy Chairman. There shall be paid to the Speaker and Deputy Speaker of the Legislative Assembly and to the Chairman and the Deputy Chairman of the Legislative Council such salaries and allowances as may be respectively fixed by the legislature of the state by law, and until provision in that behalf is so made, such salaries and allowances as are specified in the second schedule. Article 187. Secretariat of State Legislature. The House or each house of the legislature of a state shall have a separate secretarial staff, provided that nothing in this clause shall, in the case of the legislature of a state having a legislative council, be construed as preventing the creation of posts common to both houses of such legislation. The legislature of a state may by law regulate the recruitment and the conditions of service of persons appointed to that secretarial staff of the House or the houses of legislature of the state. Until provision is made by the legislature of the state under clause 2, the governor may, after consultation with the Speaker of the Legislative Assembly or the Chairman of the Legislative Council, as the case may be, make rules regulating the recruitment and the conditions of service of persons appointed to the secretarial staff of the Assembly or the Council, and any rules so made shall have effect subject to the provisions of any law made under the said clause. Conduct of business. Article 188. Oath or affirmation by members. Every member of the State Legislative Assembly and the Legislative Council of a state shall, before taking his seat, make and subscribe before the governor or some person appointed in that behalf by him an oath or affirmation according to the form set out for the purpose in the third schedule. Article 189. Voting in houses, power of houses to act notwithstanding vacancies and quorum. Save as otherwise provided in this Constitution, all questions at any sitting of a House of the Legislature of a state shall be determined by a majority of the members present and voting, other than the Speaker or the Chairman or the person acting as such. The Speaker or Chairman or person acting as such shall not vote in the first instance, but shall have and exercise a casting vote in the case of inequality of votes. A House of the Legislature of a state shall have power to act, notwithstanding any vacancy in the membership thereof, and any proceedings in the legislature of a state shall be valid, notwithstanding that it is discovered subsequently that some person who was not entitled to do so sat or voted or otherwise took part in the proceedings. Until the legislature of the state by law otherwise provides, the quorum to constitute a meeting of a House of the Legislature of a state shall be 10 members, or 1/10 of the total number of members of the House, whichever is greater. If at any time during a meeting of the Legislative Assembly or Legislative Council of a state there is no quorum, it shall be the duty of the Speaker or the Chairman or the person acting as such either to adjourn the House or to suspend the meeting until there is a quorum. Disqualification of members. Article 190. Vacation of seats. No person shall be a member of both houses of the legislature of a state, and provision shall be made by the legislature of the state by law for the vacation by a person who is chosen a member of both houses of his seat in one house or the other. No person shall be a member of the legislatures of 2 or more states specified in the first schedule, and if a person is chosen a member of the legislatures of 2 or more states, then at the expiration of such period, as may be specified in Rule 1 made by the President, that the person's seat in the legislatures of such states shall become vacant, unless he has previously resigned his seat in the legislatures of all but one of the states. If a member of a House of the Legislature of a state becomes subject to any of the disqualifications mentioned in Clause 1 of Clause 1 or Clause 2 of Article 191, or resigns his seat by writing under his hand addressed to the Speaker or the Chairman, as the case may be, and his resignation is accepted by the Speaker or the Chairman, as the case may be, his seat shall thereupon become vacant, provided that in the case of any resignation referred to in subclause B, if from information received or otherwise, and after making such inquiry as he thinks fit, the Speaker or the Chairman, as the case may be, he is satisfied that such a resignation is not voluntary or genuine, he shall not accept such a resignation. If for a period of 60 days a member of a House of the Legislature of the state is without permission of the House absent from all meetings thereof, the House may declare his seat vacant, provided that in computing the said period of 60 days, no account shall be taken of any period during which the House is prolonged or is adjourned for more than 4 consecutive days. Article 191. Disqualifications for membership. A person shall be disqualified for being chosen as and for being a member of the Legislative Assembly or Legislative Council of a state if he holds any office of profit under the Government of India or the government of any state specified in the first schedule, other than an office declared by the legislature of the state by law, not to disqualify its holder. If he is of unsound mind and stands so declared by a competent court, if he is an undischarged insolvent, if he is not a citizen of India or has voluntarily acquired the citizenship of a foreign state, or is under any acknowledgement of allegiance or adherence to a foreign state, if he is so disqualified by or under any law made by Parliament. Explanation. For the purposes of this clause, a person shall not be deemed to hold an office of profit under the Government of India or Government of any state specified in the first schedule by reason not that he is a minister either for the Union or for such state. A person shall be disqualified for being a member of the Legislative Assembly or Legislative Council of a state if he is so disqualified after the 10th schedule. Article 192. Decision on questions as to disqualifications of members. If any question arises as to whether a member of a House of Legislature of a state has become subject to any of the disqualifications mentioned in clause 1 of Article 191, the question shall be referred to for decision of the governor and his decision shall be final. Before giving any decision on any such question, the governor shall obtain the opinion of the Election Commission and shall act according to such opinion. Article 193. Penalty for sitting and voting before making oath or affirmation under Article 188, or when not qualified, or when disqualified. If a person sits or votes as a member of the Legislative Assembly or Legislative Council of a state before he has complied with the requirements of Article 188, or when he knows that he is not qualified, or that he is disqualified for the membership thereof, or that he is prohibited from so doing by the provisions of any law made by Parliament or the legislature of the state, he shall be liable to respect of each day on which he so sits or votes to a penalty of 500 rupees to be recovered as a debt due to the state. Powers, privileges and immunities of state legislatures and their members. Article 194. Powers, privileges, etc. of the houses of legislatures and the members and committees thereof. Subject to the provisions of this Constitution and to the rules and standing orders regulating the procedure of the legislature, there shall be freedom of speech in the legislature of every state. No member of the legislature of a state shall be liable to any proceedings in any court in respect of anything said or any vote given by him in the legislature or any committee thereof, and no person shall be so liable in respect of the publication by or under the authority of a house of such legislature of any report, paper, vote, or proceedings. In other respects, the powers, privileges, and immunities of a state of legislature of a state, in the house of legislature of a state, under the members and the committees of a house of such legislature, shall be such as may from time to time be defined by the legislature by law, and until so defined, shall be those of that house and of its members and committees immediately before the coming into force of Section 26 of the Constitution, 44th Amendment Act 1978. The provisions of Clause 1, 2, and 3 shall apply in relation to persons who, by virtue of this Constitution, have the right to speak in and otherwise to take part in the proceedings of a house of the legislature of a state or any committee thereof, as they apply in relation to members of that legislature. Article 195. Salaries and allowances of members. Members of the Legislative Assembly and the Legislative Council of a state shall be entitled to receive such salaries and allowances as may from time to time be determined by the legislature of the state by law, and until provision in that respect is so made, salaries and allowances at such rates and upon such conditions as were immediately before the commencement of this Constitution applicable in the case of members of the Legislative Assembly of the corresponding province. Legislative procedure. Article 196. Provisions as to introduction and passing of bills. Subject to the provisions of Article 198 and 207 with respect to money bills and other financial bills, a bill may originate in either house of the legislature of a state which has a legislative council. Subject to the provisions of Article 197 and 198, a bill shall not be deemed to have been passed by the houses of the legislature of a state having a legislative council unless it has been agreed to by both houses either without amendment or with such amendments only as are agreed to by both houses. A bill pending in the legislature of a state shall only lapse by reason of the prorogation of the House or Houses thereof. A bill pending in the Legislative Council of a state which has not been passed by the Legislative Assembly shall not lapse on a dissolution of the Assembly. A bill which is pending in the Legislative Assembly of a state, or which having been passed by the Legislative Assembly is pending in the Legislative Council, shall lapse on a dissolution of the Assembly. Article 197. Restriction on powers of Legislative Council as to bills other than money bills. If after a bill has been passed by the Legislative Assembly of a state, having a Legislative Council, and transmitted to the Legislative Council, a bill is rejected by the Council, or more than 3 months elapse from the date on which the bill is laid before the Council without the bill being passed by it, or the bill is passed by the Council with amendments to which the Legislative Assembly does not agree. The Legislative Assembly may, subject to the rules regulating its procedure, pass the bill again in the same or in any subsequent session with or without such amendments, if any have been made, suggested, or agreed to by the Legislative Council, and then transmit the bill and so passed to the Legislative Council. If after a bill has been so passed for the second time by the Legislative Assembly and transmitted to the Legislative Council, the bill is rejected by the Council, or more than 1 month elapsed from the date on which the bill is laid before the Council without the bill being passed by it, or the bill is passed by the Council with amendments to which the Legislative Assembly does not agree, the bill shall be deemed to have been passed by the Houses of the Legislature of the state in the form in which it was passed by the Legislative Assembly for the second time with such amendments, if any, as have been made or suggested by the Legislative Council and agreed to by the Legislative Assembly. Nothing in this article shall apply to a money bill. Article 198. Special procedure in respect of money bills. A money bill shall not be introduced in the Legislative Council. After a money bill has been passed by the Legislative Assembly of the state having a Legislative Council, it shall be transmitted to the Legislative Council for its recommendations, and the Legislative Council shall within a period of 14 days from the date of its receipt of the bill return the bill to the Legislative Assembly with its recommendations, and the Legislative Assembly may thereupon either accept or reject all or any of the recommendations of the Legislative Council. If the Legislative Assembly accepts any of the recommendations of the Legislative Council, the money bill shall be deemed to have been passed by both houses with the amendments recommended by the Legislative Council and accepted by the Legislative Assembly. If the Legislative Assembly does not accept any of the recommendations of the Legislative Council, the money bill shall be deemed to have been passed by both houses in the form in which it was passed by the Legislative Assembly without any of the amendments recommended by the Legislative Council. If a money bill passed by the Legislative Assembly and transmitted to the Legislative Council for its recommendations is not returned to the Legislative Assembly within the said period of 14 days, it shall be deemed to have been passed by both houses at the expiration of the said period in the form in which it was passed by the Legislative Assembly. Article 199. Definition of money bills. For the purposes of this chapter, a bill shall be deemed to be a money bill if it contains only provisions dealing with all or any of the following matters, namely, the imposition, abolition, remission, alteration or regulation of any tax, the regulation of the borrowing of money or giving of any guarantee by the state, or the amendment of the law with respect to any financial obligations undertaken or to be undertaken by the state, the custody of the consolidated fund or the contingency fund of the state, the payment of money into or withdrawal of money from any such fund, the appropriation of monies out of the consolidated fund of the state, the declaring of any expenditure to be expenditure charged on the consolidated fund of the state, or the increasing of the amount of any such expenditure, the receipt of money on account of consolidated fund of the state, or the public account of the state, or the custody or issue of such money, for any matter incidental to any of the matters specified in subclause A to F. A bill shall not be deemed to be a money bill by reason only that it provides for the imposition of fine or other pecuniary penalties, or for the demand or payment of fees for the licenses, or fees for services rendered, or by reason that it provides for the imposition, abolition, remission, alteration, or regulation of any tax by any local authority or body for local purposes. If any question arises whether a bill introduced in the legislature of a state, which has a legislative council, is a money bill or not, the decision of the Speaker of the Legislative Assembly of such a state thereon shall be final. There shall be endorsed on every money bill when it is transmitted to the Legislative Council under Article 198, and when it is presented to the Governor for assent under Article 200, the certificate of the Speaker of the Legislative Assembly signed by him that it is a money bill. Article 200. Assent to bills. When a bill has been passed by the Legislative Assembly of the state, or in the case of the state having a Legislative Council, has been passed by both houses of the legislature of the state, it shall be presented to the Governor, and the Governor shall declare either that he assents to the bill, or that he withholds the assent therefrom, or that he reserves the bill for the consideration of the President. Provided that the Governor may, as soon as possible after the presentation to him of the bill for assent, return the bill if it is not a money bill, together with a message requesting that the House or the Houses will reconsider the bill, or any specified provisions thereon, and in particular will consider the disability of introducing any such amendments as he may recommend in his message. And when a bill is so returned, the House or the Houses shall reconsider the bill accordingly. And if the bill is passed again by the House or Houses with or without amendment and presented to the Governor for assent, the Governor shall not withhold assent therefrom. Provided further that the Governor shall not assent to, but shall reserve for the consideration of the President any bill which, in the opinion of the Governor, if it became law, so derogate from the powers of the High Court as to endanger the provision which that the court is by this Constitution designed to fill. Article 201. Bills reserved for consideration. When a bill is reserved by the Governor for the consideration of the President shall declare either that he assents to the bill, or that he withholds assent therefrom, provided that where the bill is not a money bill, the President may direct the Governor to return the bill to the House, or as the case may be, the Houses of the Legislature of the state together with such a message as is mentioned in the first proviso of Article 200. And when a bill is so returned, the House or the Houses shall reconsider it accordingly within a period of 6 months from the date of receipt of such message, and if it is again passed by the House or Houses with or without amendment, it shall be presented again to the President for his consideration. Procedure in financial matters. Article 202. Annual Financial Statement. The Governor shall, in respect of every financial year, cause to be laid before the House or Houses of the Legislature of the state a statement of the estimated receipts and expenditure of the state for that year. In this part referred to as Annual Financial Statement. The estimates of expenditure embodied in the Annual Financial Statement shall show separately the sums required to meet the expenditure described by this Constitution as expenditure charged upon the consolidated fund of the state, and the sums required to meet other expenditure proposed to be made for the consolidated fund of the state, and shall distinguish expenditure on revenue account from other expenditure. The following expenditure shall be expenditure charged on the consolidated fund of the state. The emoluments and allowances of the governor and other expenditure relating to his office. The salaries and allowances of the Speaker and Deputy Speaker of the Legislative Assembly, and in the case of the state having a Legislative Council, also the Chairman and Deputy Chairman of the Legislative Council. Debt charges for which the state is liable, including interest, sinking fund charges, and redemption charges, and other expenditure relating to raising of loans and services and redemption of debt. Expenditure in respect of the salaries and allowances of judges of any high court. Any sums required to satisfy any judgment, decree, or award of any court or arbitral tribunal. Any other expenditure declared by this constitution or by the legislature of the state by law to be so charged. Article 203. Procedure in legislature with respect to estimates. So much of the estimates as relates to expenditure charged upon the consolidated fund of the state shall not be submitted to the vote of the Legislative Assembly, but nothing in this clause shall be construed as preventing the discretion of the legislature of any of those estimates. So much of the said estimates as relates to other expenditure shall be submitted in the form of demands for the grants to the Legislative Assembly, and the Legislative Assembly shall have power to assent or to refuse to assent to any demand or to assent to any demand subject to reduction of the amount specified therein. No demand for the grant shall be made except on the recommendation of the governor. Article 204. Appropriation bills. As soon as maybe after the grants under Article 203 have been made by the Assembly, there shall be introduced a bill to provide for the appropriation out of the consolidated fund of the state of all monies required to meet the grants so made by the Assembly and the expenditure charged on the consolidated fund of the state, but not exceeding in any case the amount shown in the statement previously laid before the House or Houses. No amendment shall be proposed to any such bill in the House or either House of the Legislature of the state, which will have the effect of varying the amount or altering the destination of any grant so made, or of varying the amount of any expenditure charged on the consolidated fund of the state, and the decision of the person presiding as to whether an amendment is inadmissible under this clause shall be final. Subject to the provisions of Article 205 and 206, no money shall be withdrawn from the consolidated fund of the state except under appropriation made by law passed in accordance with the provisions of this article. Article 205. Supplementary, additional or excess grants. The governor shall, in the amount authorized by law made in accordance with the provisions of Article 204 to be extended for a particular service for the current financial year is found to be insufficient for the purposes of that year, or when a need has arisen during the current financial year for supplementary or additional expenditure upon some new service not contemplated in the annual financial statement of that year, or if any money has been spent on any service during a financial year in excess of the amount granted for that service and for that year, cause to be laid before the House or Houses of the Legislature of the state, another statement showing the estimated amount of that expenditure, or cause to be presented to the Legislative Assembly of the state, a demand for such excess as the case may be. The provisions of Article 202, 203 and 204 shall have effect in relation to any such statement and expenditure or demand, and also to any law to be made authorizing the appropriation of monies out of the consolidated fund of the state to meet such expenditure or the grant in respect of such demand as they have been effect in relation to the annual financial statement and the expenditure mentioned therein, or to a demand for a grant, and the law to be made for the authorization of appropriation of monies out of the consolidated fund of the state to meet such expenditure or grant. Article 206. Votes on account, votes of credit and exceptional grants. Notwithstanding anything in the foregoing provisions in this chapter, the Legislative Assembly of a state shall have power to make any grant in advance in respect of the estimated expenditure for a part of any financial year pending the completion of the procedure prescribed in Article 203 for the voting of such grant and passing of the law in accordance with the provisions of Article 204 in relation to that expenditure. To make a grant for meeting an unexpected demand upon the resources of the state when on account of the magnitude or the indefinite character of the service, the demand cannot be stated with the details originally given in an annual financial statement. To make an exceptional grant which forms no part of the current service of any financial year, and the legislature of the state shall have the power to authorize by law the withdrawal of money from the consolidated fund of the state for the purposes for which the said grants are made. The provisions of Article 203 and 204 shall have effect in relation to the making of any grant under Clause 1 and to any law to be made under that clause, as they have effect in relation to the making of a grant with regard to any expenditure mentioned in the annual financial statement and the law to be made for the authorization of appropriation of monies out of consolidated fund of the state to meet such expenditure. Article 207. Special provisions as to financial bills. A bill or amendment making provisions for any of the matters specified in subclause A to F of Clause 1 of Article 199 shall not be introduced or moved except on the recommendation of the governor, and a bill making such provision shall not be introduced in a legislative council, provided that no recommendation shall be required under this clause for the moving of an amendment making provision for the reduction or abolition of any tax. A bill or amendment shall not be deemed to make provision for any of the matters aforesaid by reason only that it provides for the imposition of fines or other pecuniary penalties, or for the demand or payment of fees for licenses or fees for services rendered, or by reason that it provides for the imposition, abolition, remission, alteration or regulation of any tax by any local authority or body for local purposes. A bill which, if enacted and brought into operation, would involve expenditure from the consolidated fund of the state shall not be passed by a house of legislature of the state unless the governor has recommended to that house the consideration of the bill. Procedure generally. Article 208. Rules of procedure. A house of the legislature of a state may make rules for regulating, subject to the provisions of this constitution, its procedure and conduct of its business. Until rules are made under Clause 1, the rules of procedure and standing orders in force immediately before the commencement of this constitution with respect to the legislature for the corresponding province shall have effect in relation to the legislature of the state, subject to such modifications and adaptations as may be made therein by the Speaker of the Legislative Assembly or the Chairman of the Legislative Council, as the case may be. In a state having a legislative council, the governor, after consultation with the Speaker of the Legislative Assembly and the Chairman of the Legislative Council, may make rules as to the procedure with respect to communication between two houses. Article 209. Regulation by law of procedure in the legislature of the state in relation to financial businesses. The legislature of a state may, for the purposes of the timely completion of financial business, regulate by law the procedure of and the conduct of business in the house or houses of the legislature of the state in relation to any financial matter or to any bill for appropriation of monies out of the consolidated fund of the state, and so far as the provision of any law so made is inconsistent with any rule made by the House or either House of the Legislature of the state under Clause 1 of the Article 208, or with any rule or standing order having effect in relation to the legislature of the state under Clause 2 of that article, such provision shall prevail. Article 210. Language to be used in the legislature. Notwithstanding anything in Part 17, but subject to the provisions of Article 348. Business in the legislature of a state shall be transacted in the official language or languages of the state, or in Hindi or in English, provided that the Speaker of the Legislative Assembly or Chairman of the Legislative Council or person acting as such, as the case may be, may permit any member who cannot adequately express himself in any of the languages aforesaid to address the House in his mother tongue. Unless the legislature of the state by law otherwise provides, this article shall, after the expiration of a period of 15 years from the commencement of this Constitution, have effected as if the words "or" in English were omitted therefrom. Provided that in relation to the legislatures of the state of Himachal Pradesh, Manipur, Meghalaya and Tripura, this clause shall have effect as if for the words 15 years, occurring therein the words 25 years were substituted. Provided further that in relation to the legislature of the states of Arunachal Pradesh, Goa, Mizoram, this clause shall have effect as if for the words 15 years, occurring therein the words 40 years were substituted. Article 211. Restriction on discussion of the legislature. No discussion shall take place in the legislature of a state with respect to the conduct of any judge of the Supreme Court or High Court in the discharge of his duties. Article 212. Courts not to inquire into proceedings of the legislature. The validity of any proceedings in the legislature of a state shall not be called in question on the ground of any alleged irregularities of procedure. No officer or member of the legislature of a state in whom the powers are vested by or under this Constitution for regulating procedure or conduct of business or for maintaining order in the legislature shall be subject to the jurisdiction of any court in respect of exercise by him of those powers.